Good afternoon, everyone. You're here for the Worker Rights and Immigration presentation put on by the Filipino Bar Association of Northern California and the California Employment Lawyers Association's Worker Outreach Committee. Today, we are giving a Know Your Rights format presentation, which means that this is not specific legal advice. It's not intended to or does not constitute legal advice. It's all informational. It's for general informational purposes only. So please don't rely on this information for your particular situation. Only your attorney will be able to advise you as to proper actions to take with respect to your particular situation. Okay. To give you just an idea of where we're headed, we are going to start with Christina Lee with some general employment law basics, as well as wage and hour. And then Glicel Sumagaysay, will be handling specific types of claims such as discrimination, retaliation, harassment, and wrongful termination, including the exhaustion of remedies that is required before filing a lawsuit for those types of claims. And then Michael Flynn will be taking on crossover issues between immigration and employment issues. With that, I would like to hand it over to Christina Lee.
Thank you so much, Glicel. I welcome everyone to this Know Your Rights presentation that we're putting on today. I'm part of the CELA Outreach Committee. I'm one of their newest members. But with respect to what I do, I work for a firm called Clarkson Law Firm, and I'm basically their plaintiff side employment attorney there. I handle wage and hour matters and also single plaintiff cases dealing with things like retaliation and wrongful termination. So thank you for being here once again. What I will be talking about today are the wage and hour laws that we have in California that are there to protect certain types of employees, okay? First off, I wanted to say by starting off that in California, you are entitled to any wages you have earned. So I'm going to start off with that. So, if you're a worker and you are earning wages, you are entitled to those wages. In California, California is is a state with very protective labor laws that protect the employees in California, but these laws protect certain types of employees. So I want to start off first by talking about what I'm referring to when I'm talking about wage and hour laws. When I'm talking about wage and hour laws in California, I'm talking about laws that cover things such as minimum wages, overtime, meal and rest breaks. Those are the types of laws that I'm talking about. Whether these types of wage and hour laws cover you in California depends on your employment status. So if you can go ahead and move to the next slide, that'd be great. So let's look at the different types of employment status. You can be, as I listed here, there's the employee versus independent contractor status. There's also the non-exempt employee versus exempt employee status. Generally, the perks and protections that come with these wage and hour laws that I'm talking about, the overtime, the meal breaks, this typically only applies to non-exempt employees. We'll be talking about that further in the next couple of slides. Can you move to the next slide, please? Thank you. So let's talk about the employee versus independent contractor. Wage and hour laws only cover you if you are an employee. And in California, under the law, you're presumed to be an employee unless you're an independent contractor. So let's take a look at what an independent contractor is in California. Under the traditional independent contractor definition, typically an independent contractor renders some type of service under agreement that says that he or she will produce a specified result for a specified pay. And this independent contractor will maintain control over the means by which, this work takes place. Okay. So the idea is the independent contractor is not supposed to be an employee. It's someone who is retained by, a company, and they are in an agreement to do a certain type of work for this company, but most of the work that is done is under their control. Like how they're going to do it is under that independent contractor's control. Okay. In California, though, there's been other factors that have recently come into play in the determination of whether a person is an independent contractor or not. So if you can move to the next slide. I'm not going to go through each of these things in detail, but the idea is in California over the last couple of years, they've put in some tests in our case law to help people further determine whether a person is an independent contractor or not. So just looking through this list, I guess I'll just quickly zip through it. Why not? It says here, some of the other factors are, whether the worker is engaged in a distinct occupation or business, the kind of occupation, and whether it's typically done by the employees or independent contractors, the skill required in the particular occupation, whether the boss or the worker provides the tools and the place of work, the length of time for which the work is to be performed, the method of payment, time-based or job-based, whether the work is part of the regular business of the boss, and whether the parties believe they're creating an employer-employee relationship. So a lot of these factors deal with, what sort of control and what sort of duties this person has and what the company has in terms of control over this person. Okay. So California has been really diving deep into this area, and people really need to question nowadays if they are, I guess, classified by a company as an independent contractor. It's really important that they, go through and think through these factors to see if they are indeed an independent contractor or someone who should be deemed or classified as an employee. Okay. Because there's different ways that, the company has to treat this person depending on the status. Now we're going to go to a discussion of the non-exempt employee versus exempt employee. California labor law specifically provides that overtime rules do not apply to certain employees, and these employees are known as exempt employees. California law, our labor codes, have specific definitions for these different type of exempt employees. And so the one that's most common, the one that comes up the most, is a group called or it falls under a group that's classified as exempt, and this exemption is for executive, administrative, and professional employees. If you go to the next slide, to be considered, for example, part of this category of exempt employees, typically the employee must spend more than half of their work doing some type of intellectual, management or creative work, regularly exercise discretion and independent judgment in the performance of those duties, and earn a monthly salary equivalent to at least twice the state minimum wage for full-time employment. That is employment for 40 hours per week. Right now, I believe the minimum wage for the minimum salary for that exemption is now in 2014 $66,560 annually. So for a person to qualify under that exemption, um, they have to meet the definitions that I've just gone over. Other than that exemption, there's other different types of exemptions depending on the field. So or type of employee. So for example, other types of exemptions exist in the computer software field. There's exemptions dealing with certain types of licensed physicians, doctors, and surgeons. Certain teachers at private elementary or secondary schools are exempt. And then the last one deals with there are employees who may be hourly or commission. If they meet certain requirements, then they are also exempt as well. Okay. These are just some examples of other employees who are considered exempt who would not be subject to California's wage and hour laws dealing with overtime. So, why did we go through that whole section on these types of employees? Because, you should be aware that sometimes California employers or companies will improperly misclassify an employee. Okay, so for example, some things to keep in mind is even if an employer has you sign some sort of agreement saying that you're exempt, that does not mean you're necessarily exempt. Okay, so like going back to the administrative exemption that we talked about earlier, let's say, they say that you are an exempt employee and you're not subject to California's wage and hour laws, but your salary is like $50,000 a year and it doesn't meet the California requirement of $66,560 at this time. So, in that circumstance, you don't meet that exemption and you should be qualified as a non-exempt employee. Okay. Another thing is just because you're paid a salary, that does instead of an hourly wage, don't instantaneously think that you are not, that you're an exempt employee. Just from the example I told you, that could still be the case where you're not making enough based off of, your salary to be considered an exempt employee. So let's say you are a non-exempt employee. You don't fall under any of the exemptions, okay? And you're typically an hourly paid, employee. So what does that mean? You are entitled to, in California, certain protections. And on this page, there's a general overview of these protections. So, there's certain labor codes dealing with minimum wages in California. There's certain labor codes dealing with overtime, meal breaks, and rest breaks for the most part. So I'm going to go through these quickly in the next couple of pages. Minimum wages with a few special exemptions. All California employees, must be paid minimum wages set by the state's wage and hour laws. The current minimum wage in California in 2024 now is $16. But I wanted to note that different cities in our states and counties may have a different higher minimum wage. So since my understanding, this organization is up in Northern California mainly, some notable cities where they have higher minimum wages are cities like Berkeley or Sunnyvale, Emeryville, San Francisco. Okay, they have slightly higher minimum wages. Also, something to note too is sometimes depending on the industry that you are working in, they also have higher minimum wages. So, for example, there was legislation passed not too long ago where fast food workers are now being paid a higher than, state minimum wage, okay? Or there's also certain healthcare workers, depending on what they're doing, they are also entitled to a higher minimum wage that is higher than the California state minimum wage. So I think the best thing to do, depending on your circumstances, definitely do your research and make sure to reach out to a knowledgeable employment attorney to help you if you have questions about your specific situation. Can you move to the next slide? Okay. So overtime. California overtime laws only apply to non-exempt employees. Employers may not get around this requirement by requiring or pressuring employees to work off the clock. This is many of you may know this already, but we'll just go through each just as a reminder. For time and a half overtime, employers must pay non-exempt employees time and a half overtime for work in excess of 8 hours in one workday or 40 hours in one work week. Employees are also entitled to time and a half overtime for the first 8 hours of work that they do on the 7th day of a work week. And that is if you work 7 consecutive days. Okay. Also, there's double time overtime. In addition, California wage and hour laws require employers to pay employees double overtime. That is if they work in excess of 12 hours in any workday, or they work in excess of 8 hours on the 7th day of a work week if they're working 7 consecutive days. Also, there's meal and rest break laws in California. California wage and hour laws require employers to provide non-exempt employees with regularly scheduled meal and rest breaks. Let's talk about meal breaks first in the next slide. So most non-exempt California employees who work more than 5 hours a workday must be given a meal break of at least 30 minutes. However, if the employee will work no more than 6 hours, he or she may agree to waive the meal break. The meal break must be duty-free, uninterrupted, and the employee should be able to leave the workplace premises. One thing I wanted to mention too is sometimes people don't understand when they're supposed to start their meal break. So if you start at, for example, you're working from like 8 to 5:30, and you're starting at 8 a.m., you should be starting your first meal break at 12:59 p.m., which is right before the end of your 5th hour of work. So that's just an example of when you should start your work in that scenario. I'm going to just go through the last paragraph quickly here. Employees who work more than 10 hours a day must receive a second 30-minute meal break. The employee may waive the second meal break if he or she did not waive the first meal break and will not work more than 12 hours in that day. So let's go to rest breaks. Non-exempt employees are entitled to a 10-minute, it's 10-minute break. Trying to read. 10 minutes of rest period for each 4 hours or substantial fraction thereof that they work. However, employees are not entitled to rest breaks for work shifts that are less than 3.5 hours long. Like meal breaks, the break must be duty-free, uninterrupted, and the employee should be able to leave the workplace premises. Let's go to the next slide. If your employer is denying you meal and rest breaks, this can also mean that you're just not getting a compliant meal or rest breaks. For example, let's say you start a meal break or you start a rest break and it's interrupted and you don't get the full break, it would fall under this too. Or if your meal or rest break is late, you would be entitled to receive a penalty of 1 hour of wages per day you were denied any meal or rest break. Any rest break, an additional 1 hour of wages per day you were denied any meal break, for a maximum penalty of 2 hours of wages per day. So I just want to end off with my section with some general things, general discussions about what your options are if there's any sort of violation of wage and hour laws. Just note for the statute of limitation that you have to generally make a claim with these wage and hour claims is typically 3 years. And it's noted here, it could be 4 years in court. There's a way for us to extend it if we make certain claims. You may be able to seek damages, penalties, interest, and attorney's fees and costs. You can also, you have the option of filing a claim with the California Labor Commissioner's Office. You can seek assistance from counsel as well. And then one thing I wanted to note here, which, just so you know, many times employers do ask you to sign an arbitration agreement when you, sign on to become an employee with the company. That can be a really long and lengthy discussion on the details of arbitration agreements, but just know if you do sign one, it could impact your ability to make certain claims, wage and hour claims, and it may impact your ability on where you can pursue that claim. Okay, so that's all I wanted to say on that. I like to, I'm going to end my presentation, and we're going to move on to the next person.
Okay, thank you very much, Christina. So, as I stated earlier, I'm now going to discuss an unfortunately pretty prevalent issue with employment law, and that is discrimination, harassment, retaliation in the workplace. Okay, so I'll start with a few basics. Under federal law, which means for federal employees, and postal service employees, employees of the Veterans Affairs, for example, they're subject to federal laws. And so federal law prohibits discrimination on the basis of race, color, religion, sex, national origin, and disability. Generally speaking, federal law is a little less favorable to employees than California law is. And so most of my presentation will focus on California law. Okay, so California private employees and most public employees who are not federal employees are subject to the California Fair Employment and Housing Act if their employers employ 5 or more employees. Okay, and the California Fair Employment Act, or the FEHA, protects employees from discrimination on the basis of their race or color, their ancestry or national origin, their religion, their age of 40 and over, their disability, which includes mental and physical, and their gender. Pregnancy discrimination is known to be gender discrimination, okay, because you're a woman that you're being discriminated against on the basis of pregnancy. Okay, sexual orientation, gender identity, gender expression, medical condition, which is cancer specifically, genetic information, marital status, military or veteran status, and most recently added reproductive health decision-making. Okay, and the FEHA also protects employees from harassment. Now, all employees, no matter how many employees an employer has, are protected against harassment on the same bases as those I just listed for discrimination. Okay, things to note about harassment based on a protected status such as gender. Um, it can be very overt or it can be subtle. It can be obvious. Um, Types of harassment can include um, being scrutinized more harshly than others, being reprimanded, humiliated against in front of your peers, um, receiving comments related to your status, sexually harassing comments, or if it's harassment based on race, it could be using the N-word in front of you or referring to slavery related historical comments. Okay. Something else that can constitute harassment is repeated failure to provide a reasonable accommodation. Okay. An employer can just keep rejecting your requests for a reasonable accommodation. That can constitute harassment. Employees have rights. They have rights to report harassment, discrimination, or retaliation. To whom? They can report to their supervisor, human resources department, anyone with the ability to do something about the harassment, discrimination, or retaliation. Okay. Employees can, but don't have to use the employer's complaint process or form. Okay. So an employer can't say, well, you didn't use the form, therefore you didn't properly report harassment. That's not a valid argument under the law. Okay. Employers have an affirmative and mandatory duty to prevent harassment, discrimination, and retaliation, right? So what does that mean? Once an employer finds out that there's harassment, retaliation, or discrimination going on, they have to take steps such as initiate an investigation into the allegations. If it's warranted, they have to discipline the harasser or discriminator or retaliator. Okay, and if warranted, they need to terminate the harasser, discriminator, or retaliator. Okay, I'm going to talk about a specific type of discrimination now that is prevalent and increasingly prevalent, I think, because we're all becoming more aware of mental illness, right? Some mental illnesses are qualified as disabilities, okay, under the law. So a disability is a physical or mental condition that limits a major life activity, okay? It could be seeing, hearing, or working are major life activities, okay? But whatever the condition is, it only needs to limit it. And this is different from the federal version of disability discrimination law, which requires that the condition substantially limit a major life activity. Okay, so this is one example of how California law is more favorable than federal law for employees. Okay, disabilities can be cancer, for example. Or it could be a pregnancy-related injury. So there's the pregnancy itself, which is not a disability, but if the mother unfortunately suffers from a condition that is related to childbirth or the pregnancy, that could be a disability. A disability could also be major depressive disorder or anxiety or PTSD. Okay, and so under disability discrimination laws, employers cannot fire or give away an employee's job without first engaging in what's called the interactive process to determine if there's a reasonable accommodation that the employer could give the employee in order to perform the essential functions of the employee's job. Okay, so what's the interactive process? When an employee requests a reasonable accommodation, the employer must start to engage in the interactive process. Okay. Um, when the employer is on notice that an employee might possibly need a reasonable accommodation, the employer must also engage in the interactive process with the employee. Okay. And specifically, the interactive process involves an individualized assessment of the job and the specific physical or mental limitations um, that's directly related to the reasonable accommodation request. Okay, so for example, an employer must take the employee's job description, whether written or actual. You know, it doesn't have to just be what's on a written job description that was posted at the beginning of the employee's job. Um, it needs to reflect what the actual job duties of the employee are in reality. Okay. And the employer must then evaluate whether or not the physical or mental limitations allow the employee to perform each one of those job duties. Okay. More specifically, the essential job functions. Not every job duty on a job description is an essential function. Okay. Essential functions are those which the job would not exist without, for example, or those which the job was created for example. Okay. So it doesn't have to be every single job duty on a job description that an employee must be able to perform with or without an accommodation. Okay. And then lastly, about interactive processes, they must be timely. An employer cannot put off having to engage in the interactive process with the employee until it feels like it later, okay? Because otherwise, in the meantime, the employee's condition is becoming worse and worse, okay? Um, Types of reasonable accommodations can include leave, right? Because of a disability. So for example, in the scenario with a pregnancy related injury, the woman with the pregnancy related disability might require an additional leave after giving birth due to the disability. Okay. Another example is light duty, which is a term for perhaps in a job where the employee is required to lift a certain amount of pounds, um, that duty be restricted to a lesser amount of pounds that the employee can lift. Okay. Other reasonable accommodations include appropriate equipment to do a job, like, for example, something as simple as a chair that is the correct height to the employee's desk. Okay. Periodic time off to attend doctor's appointments. That's a reasonable accommodation. And then, if warranted, a comparable position that will allow the employee to be able to work for the employer. Okay, and so filing with an administrative agency prior to filing a lawsuit for discrimination, retaliation, harassment is required. The California Civil Rights Department is the agency with which California employees must file a charge within 3 years from the date of harm. Okay. And then after that 3 years, or after an employee obtains what's called a right to sue, the employee then has 1 year after that to file a lawsuit. Okay. Federal employees must file a charge with the Equal Employment Opportunity Commission within 180 days from the day the discrimination took place. Or if it's a non-federal employee filing with the EEOC, they must file within 300 calendar days if, for example, the California Civil Rights Department enforces the law on a similar basis. In other words, rights that are protected under the Fair Employment and Housing Act are also that the EEOC also protects. An employee can file a charge within 300 calendar days in that scenario. And then after an employee obtains what's called a right to sue from the EEOC, an employee has 90 days from the date of the right to sue issuance to file a lawsuit. Okay. All right. So I'd like to hand it off now to Michael Flynn.
Thank you, Glicel. Thanks, Christina. So some people might wonder, how does their immigration status affect their rights as an employee? I think like Christina said earlier, as long as you're actually working, you have a right to get paid for the hours that you work, regardless of your status. And you also have a right to a workplace free of discrimination and harassment. And there's additionally some protections under the California Labor Code that the California legislature has passed within the past 10 years that specifically would prohibit discriminating in terms of the pay, promotions, or benefits based on immigration status, national origin, or language, which that's always been a version of employment anti-discrimination law. But the newer protections that are passed help to navigate and guarantee protection in some more nuanced situations. So, for example, the labor code, California Labor Code, prohibits employers from asking employees for different types of employment authorization documents or additional employment authorization documents than what is required on the federal Form I-9. And the additional labor code protections also prohibit employers from asking employees to re-verify their employment authorization when it's not required by the law. And they also prohibit employers from threatening to report employees to immigration authorities because of the employees' exercise of their rights. So that comes out sometimes, for example, where, and sometimes we hear about like larger workplaces where employees try to organize a union, and then employers might look for some reason to weaken their movement and not acknowledge their rights or negotiate with them to give them better benefits. And they might do we've heard about stories about employers doing a employment authorization re-verification, and that could possibly be a form of retaliation if you can show that it was in retaliation for the protected rights. And one thing that's not on the slide I wanted to touch on here is that in some situations where someone doesn't have work authorization, but they're actually working, and so they have the same rights we're talking about, but the employer does something that is a violation of the criminal laws, or the employee suffers a workplace violation of a serious criminal law, in some situations, they could be entitled to a U visa. And so in employment law, we see that come up where situations, it's called peonage, which is like extreme exploitation, witness tampering, where maybe an employer tries to convince another employee to lie about like the employee's claims against the employer. Also like a felonious assault, if there's like a workplace assault that happens. Those are situations that could come up in employment and where it could lead to someone, if they are the victim of a crime on that list and they suffer serious harm, a law enforcement agency can certify them to be able to be eligible for a U visa. And that could be a law enforcement agency that includes the California Civil Rights Department that Glicel pointed out earlier, or the Labor Commissioner, which Christina was referring to with respect to one way to bring forth wage claims. All right, we can move on to the next slide, please. And I also want to touch on the California Fair Chance Act, which is a newer change in California law within the past 10 years that's intended to help give everyone more equal opportunities to work. And so in general, it prohibits most employers from asking about criminal history before they make a conditional job offer. It's only after they've looked at the person's credentials and determined that they can make a conditional offer that they would be allowed to look at the person's possibly do a criminal background check. And of course, as you could imagine, this would vary based on the job, the type of job, the scenario where people are working. People who work in schools or certain health facilities with vulnerable populations, of course, are required as a matter of course to do background checks. And but this law applies to private employers and public employers, and generally is intended to give people more of a fair chance. The employers, as long as this applies to them, they're not supposed to use a conviction or arrest that was expunged, or there's been a certificate of rehabilitation. I put a link here. You can one option to clean your record could be to go to the local public defender office, and they have programs that might be called a clean slate program, for example, to help clean your record and make it easier to get a job, hopefully. We can move on to the next slide, please. And something else that comes up sometimes we hear about is where people wonder whether an employer could discriminate against them based on their political opinion, or maybe because they went to a protest or made some political statement on social media. Well, generally speaking, Labor Code 1101 protects employees' rights to free speech about politics, and it's a clear cut if it's outside the workplace. But of course, if someone is on the job and making a statement that might appear to be in the name of their employer, and the name of their employer, that could be a different situation, because where an employer requires a particular like editorial viewpoint or even political viewpoint as whenever someone's on the job, that can be potentially required. But there could be some nuance there too, of course, standing up against something that would be an illegal or some unlawful activity, as also would be protected under Labor Code 1102.5. So I'm finished with that slide too. So we put our contact information here. If people have specific questions about their specific situations, they can reach out to us, and we can do our best to provide a consult and see if there's some way we can provide guidance. And Glicel gave a advisal at the very beginning of the presentation about this is not legal advice. We're just providing legal information. We can't really give legal advice that's reliable or guaranteed for anyone without doing an investigation of their facts and the law applying to their situation, doing a thorough look at what documents and evidence might be available, because otherwise we're speaking in more generalities about how the law applies for your particular situation. There could be a variety of factors that might relate to whether any particular decision is the best thing to do.
All right. Thank you very much, Mike. Thank you, Christina. Does anyone else have anything to add? All right, then with that, we hope you enjoyed our presentation. As Mike said, if you need specific questions to be answered, feel free to contact any of us. And good luck in your employment disputes. Thank you very much for joining us.